Hello, everyone, and welcome to today's webinar on criminal offenses and PR applications. My name is Ruchika, and I'm the project coordinator at Costi Immigrant Services, and I will be your presenter. Thank you for being here with me today. This webinar has been brought to you by the International Student Connect project. The Government of Ontario funds the Bilingual International Student Connect project to provide support to international students and their families in Ontario. Costi Immigrant Services, a community-based multicultural agency, serves over 39,000 clients annually from 17 locations in the Greater Toronto Area. Costi coordinates the ISC project across Ontario. In this webinar, we will be discussing who is a permanent resident, immigration categories, what are the pathways to PRs for international students, a police certificate, PR application, and a criminal record, reasons for criminal inadmissibility, overcoming criminal inadmissibility, and how would a permanent resident status be lost. Let's begin by looking at who is a permanent resident. A permanent resident is someone who has been given permanent resident status by immigrating to Canada but is not a Canadian citizen. Permanent residents are citizens of other countries except Canada. A person in Canada temporarily, like a student or foreign worker, is not a permanent resident. There are various immigration categories which are defined by IRCC. So here you will see listed on this slide the category along with their description. So we have express entry. These are people who immigrate to Canada as a skilled worker. Provincial nominees. These are individuals who are nominated by a Canadian province or a territory. Family sponsorship, when a person who is living in Canada decides to sponsor their spouse, parents, or grandparents. Quebec skilled workers, these are individuals who immigrate under a skilled worker category to Quebec. The Atlantic immigration pilot. Caregivers, these are individuals who immigrate to Canada by providing care for children, elderly, or those with medical needs. For example, nannies come under this category. Refugees, these are individuals who come to Canada under the refugee category, and they are often sponsored privately or sponsored by the government. Agri-food pilot, northern and rural immigration pilot, self-employed and startup visa. These are various other categories in which individuals can come to Canada. What are the pathway to permanent residency for international students? The main way an international student can obtain a permanent resident status in Canada is through the post-graduation work permit program, which is PGWPP. This program allows students who have graduated from eligible Canadian designated learning institutions to obtain an open work permit to gain valuable Canadian experience. Skilled Canadian work experience in National Occupation Classification, which is also called NOC, skill type O, or skill level A or B that is gained through this program, helps graduates qualify for the permanent residency in Canada through the Express Entry program within the experience class. When you apply to become a permanent resident or a Canadian citizen, you and your family members must include a police certificate. When you apply as a visitor, student, or temporary worker, a police certificate may be required. Now, what is a police certificate? A police certificate is a statement or a record that proves you don't have a criminal record or if you have one, a copy of your criminal record. It helps confirm if there are any reasons that you might not be allowed to come to Canada. For more information, please visit the website which is mentioned on this slide. These certificates are called by various names. They could also be called a good conduct certificate, a judicial record extract, or any other names followed by different countries. How is permanent resident application and a criminal record linked? A criminal record can make someone ineligible for permanent resident status and will negatively impact a PR application, as it is of course clear that Canadians do not want individuals who have a criminal record to come to Canada. Having a Canadian criminal record reduces your chances of obtaining permanent resident status or even a Canadian citizenship. It is usually necessary to have your record cleared, obtain an approval of criminal rehabilitation, or be deemed rehabilitated before your application will be approved. Any criminal charges against you can negatively affect your Canadian immigration status, even if the charges were dropped or dismissed. A non-conviction record can prevent you from or make you lose your immigration status, prevent you from applying for Canadian citizenship, and get you deported from the country. Some people are not allowed to come to Canada. They are inadmissible under the Canadian immigration law. A Canadian immigration officer will decide if you can enter to Canada when you apply for the visa or the ETA or at the port of entry, which is at the airport or at the border crossing. For more information, please visit the website which is mentioned on this slide. What is criminal inadmissibility? This term describes people who are not allowed to enter or stay in Canada because they have committed or have been convicted of a crime. If you were convicted of a crime when you were under the age of 18, you may still be allowed to enter Canada. Let's see what are some of the reasons why people are not allowed to come to Canada. For example, if you have committed a theft, an assault, manslaughter, or you have even done dangerous driving, you were in possession of trafficking in drugs or controlled substances, or you are a part of an organized crime, including membership in an organization that takes part in organized criminal activity, people smuggling, or even money laundering. These are some serious offenses. In Canada, it is legal to use cannabis. You must be 19 or older to buy, use, possess, or grow recreational cannabis and can possess a maximum of 30 grams of dried cannabis or equivalent in public at any time, bought online by the Ontario Cannabis Store or at a Gaming Commission of Ontario licensed store. You can smoke and vape cannabis wherever the smoking of tobacco is permitted. How are immigration and cannabis linked? It is illegal to transport cannabis across Canada's national borders. Individuals who act outside the law can face criminal charges under the Federal Cannabis Act. As a result of this, permanent residents might lose their status and temporary residents may not be able to enter or stay in Canada. What are the driving offenses here in Canada? Please never drink and drive. Never drive under the use of or the influence of cannabis. Driving a vehicle when you're impaired by alcohol or by cannabis is illegal and dangerous. You're not only risking your life, but the lives of other people too. If you drive while impaired by alcohol or drugs, including cannabis, your license can be suspended and you may be inadmissible for serious criminality. This means you won't be able to enter or stay in Canada unless you have a temporary resident permit. Please visit this website, which is ontario.ca/page/cannabis and driving to get detailed information about this. These are some important resources mentioned on the slide. There are two websites which lists criminal offenses in Canada, and the second one talks about the Controlled Drug Substance Act. Depending on the crime, how long ago it was, and your code of conduct since, you may still be allowed to come to Canada if you convince an immigration officer that you meet the legal terms of deemed rehabilitation, you have applied for rehabilitation and were approved, you were granted a record suspension, and you have a temporary resident permit. What are some of the ways of overcoming criminal convictions or inadmissibility? The first one is deemed rehabilitation. This means that enough time has passed since you were convicted that your crime may no longer bar you from entering Canada. You may be deemed rehabilitated depending on the crime. If enough time has passed since you finished serving the sentence for the crime, and if you have committed more than one crime. In all the cases, you may only be deemed rehabilitated if the crime committed outside Canada has a maximum prison term of less than 10 years if committed in Canada. Moving on to individual rehabilitation, this means that you are not likely to commit new crimes. You can apply for individual rehabilitation to enter Canada. The minister or the delegate may decide to grant it or not. To apply, you must show that you have met the criteria, you have been rehabilitated, and be highly unlikely to take part in future crimes. Also, at least 5 years must have passed since the end of your criminal sentence and the day you committed the act that made you inadmissible. Record suspension or discharge. If you have been convicted in Canada and want to apply for a record suspension, which was formerly called a pardon, check with the Parole Board of Canada. If you get a Canadian record suspension, you will no longer be inadmissible. If you received a record suspension or a discharge for your conviction in another country, check with the visa office that this serves the country or the region where you live. It will tell you if the pardon is valid in Canada. A temporary resident permit lets you enter or stay in Canada if it has been less than 5 years since the end of your sentence or you have valid reasons to enter Canada. Even if the reason you are inadmissible seems minor, you must show that the visit is valid. An immigration or border service officer will decide if you need to enter or stay in Canada outweighs the health and safety risks to the Canadian society. An important tip: if you are applying for criminal rehabilitation along with your temporary resident, which is a visitor visa, the study visa, or work permit application, you can submit everything together and apply at the nearest visa application center. The website, which is mentioned on this slide, will take you to all the application centers. How does a person lose a PR status? Even if an individual has been a permanent resident for many years since childhood, a criminal record can cause the person to lose their permanent residency status, and at worst, it can also cause a person to be removed from Canada. If a permanent resident is charged with a crime, the police will report this fact to the Canadian Border Service Agency. From this point, CBSA will investigate the severity of the crime and determine what effect it will have on the individual's immigration status. If a permanent resident is charged with a crime, the police will call the fact to the CBSA. From this point forward, the CBSA will investigate the severity of the crime and determine how effect it will have on the individual's immigration status. The Immigration and Refugee Protection Act states that a permanent resident is inadmissible to Canada on the grounds of criminality or serious criminality for number one, convictions inside Canada for a federal offense punishable by maximum jail term of at least 10 years, or of two offenses under any Act of Parliament. Number two, convictions outside Canada that, if committed in Canada, would be number one, punishable by a maximum jail term of at least 10 years, or considered an indictable offense, or thirdly, two offenses not arising out of a single occurrence under the Act of Parliament, or committing an offense under the Act of Canada on entering Canada. Some of the resources are mentioned on this slide. Firstly is the Immigration, Refugee and Citizenship Canada's website. Then second one is the visa offices outside Canada. Then the Parole Board of Canada and a legal helpline. If you have any questions, or you can contact us by phone or via email. Our phone number is 1-844-871-4567 and our email is isc@costi.org. Thank you everyone for listening to this webinar, and please do not hesitate to contact us if you have any questions.